Hi everyone, Derek Johnson with Tatango.com. I'm here with Joe Bowser from Innovista Law and the TCPA Defense Force. And we're talking today about who is responsible for TCPA compliance. And I guess who's responsible and then who is held accountable, I guess are two different kinds of, or maybe they're the same thing, right?
I think lawyers would use the term liability.
Okay.
Who's liable for the SMS in question, but that's a different way of saying responsibility in terms of if the plaintiff gets a judgment against you, who has to satisfy it?
Okay.
Right?
And I guess there's a lot of different players in text message marketing. You have the brand, so let's say the retailer. You have software providers like Tatango. You have marketing or digital agencies that might be helping a brand use a software provider like Tatango. Who's responsible and who gets sued, who gets to back out of the lawsuit? I've heard a lot of different kind of opinions on this, so maybe you can help me out.
Sure. Well, so let's just start with the law.
Yep.
So the law holds the sender or the initiator of a message liable.
Okay.
Right? So the question is, who sent it or who initiated it? Right? So that can get us back to the brand. So a brand doesn't absolve itself of liability. It can't just wash its hands of TCPA liability just because it hired a third party
like an
to
agency.
hit send on a message to develop the campaign, right? So your campaign can be liable if they're actively involved. The platform provider can be liable if they're actively involved. And all three can be liable if they're actively involved. So the courts use a test of what's called vicarious liability. So the person to hit send is necessarily liable because they're the sender. But you can go upstream to find out who hired them. So it might be an agency. It might be the brand directly. But just like when the UPS driver rear ends you in the street, you can sue the driver and you can sue UPS because that driver is doing UPS's business. It is a so-called principal-agent relationship, right? UPS is the principal. They're getting paid to deliver the package, and that driver is the agent. And someone who's injured in what's called a tort claim, and TCPA is a tort claim, can sue anybody who caused their damages, or all of them.
Interesting.
So typically, the plaintiff's attorney will sue everybody, right? And then you start looking who's got the deep pockets, who may have insurance, and then between the defendants, you start looking at what are the contractual arrangements between the three of you say. Did one of you agree to defend and indemnify me? Did one of you agree to take responsibility, exclusive responsibility? Right.
So it's more contractual between the parties.
Right, but the plaintiff never has to care about any of that. They don't care, because they get to sue all of you.
And you have to figure it out with everybody else.
On the back end.
Right.
But the court can hold anyone who qualifies as a sender liable. And so anyone who has an active role in the delivery of that message that violated the TCPA can be held liable. So you don't wash your hands just because you hire a third party. That's the classic UPS.
I've heard about there's an agency is doing it, it's not my problem. It is your problem essentially.
If it's your good or service being promoted, you should assume you have exposure.
And what are the penalties? I know we've reviewed this in other videos, but how much exposure are we talking here?
The base statutory damages under the TCPA is $500 per call. And if you are shown to have willfully violated the law, it's $1,500 a message.
Wow. So
each message.
Each text message, each person.
To each person.
So this is not something you want to take lightly. And even if you have three different parties, you still need to be compliant and still be concerned and aware of the TCPA, because this is not something you can kind of shift blame, and it's very expensive, obviously.
The exposure is quickly in the millions and not uncommonly into the billions.
Wow. Do you think as an attorney, should each party have their own attorney? Should they all be working together on TCPA compliance? I know a lot of brands use agencies that use software that have different people involved in the campaign. What are some best practices as to how to get everybody compliant?
Right. Well, certainly attorneys should be involved at each stage because there are times when one attorney can't represent all three, like the defense and indemnification provisions we were talking about. So if the brand wants the agency to assume more responsibility, that attorney can't.
So that's the contract law between the parties.
Exactly.
And then in terms of setting up the campaign and running the campaign, like, the double opt-in message, the disclosures that, are shown to the consumer when they opt in, it seems like kind of everybody needs to be involved and everybody needs to be aware of the TCPA, because if one person isn't, that can screw everybody.
Well, right. If the attorney's only at the brand level and they're not getting good intel back from the agency or the marketing company about what's actually going out the door, it didn't matter if you approved the campaign if it adapts along the way. So you want to keep them involved because, again, the TCPA has many inflection points about who you're calling, what you're calling about, whether it's an informational or a marketing call or a message. So you want to make sure that everyone is towing the line as the message goes out.
It seems almost like from a software provider standpoint, as a brand, a software provider, they'll always say they're TCPA compliant. But maybe a brand shouldn't take that, just as is. They should also, have their own counsel review things as well. Because, again, the brand is liable at the very end of the day as well.
I don't even know what that means to say that a platform provider is TCPA compliant. Because if they're not involved in what the messages are saying, if they're not involved in the achievement of consent before those messages go out, if they don't have visibility into that,
they can't determine it.
They can't put a seal of approval when they're missing key pieces of the puzzle.
So it sounds like just everybody needs to be involved in TCPA compliance, everything from the people that are composing the message to the software that's built it, the attorneys, everybody needs to be on the same page so that, one part of the component is not, having issues and no one else knows and everyone else is liable for that one component.
Right. Just because Microsoft provides Outlook doesn't mean that Microsoft knows whether the email I'm about to send defames someone or violates someone's IP. Right?
Interesting.
So,
wow. Okay. So it really comes down to that really everybody involved in the chain is liable for TCPA violations. So that's why it's so important for, I think, brands and software providers and attorneys and marketing agencies all to get on the same page, come up with a strategy, and really make sure that they're following the TCPA to the T.
Right, because the TCPA, at the end of the day, is designed to keep consumers happy. So the last thing you want is your agency to go off on a rogue campaign. It damages the brand, and you just got yourself exposed to a whole bunch of TCPA lawsuits because they're promoting your product.
So really having a good view of everything that's going on.
You're in court and your consumers are upset.
That's the worst, to be honest. Well, that is definitely something you do not want to do as a text message marketer. Again, my name is Derek Johnson with Tatango.com, sitting with Joe Bowser from Innovista Law and the TCPA Defense Force, and we're answering your TCPA text messaging questions. Thanks for watching our video today. If you like this video, be sure to give us a thumbs up on YouTube. If you want to see more of these types of videos, be sure you subscribe to our YouTube channel. And if you have comments or questions, please leave a comment or question in the comment section below.